Good evening. I am Barry Kamins, President of the City Bar Association, and it is my pleasure to welcome you to the 6th Annual Justice Ruth Bader Ginsburg Distinguished Lecture on Women and the Law. I would like to take this opportunity to thank our distinguished panel, the Honorable Judith S. Kaye, the Honorable Shirley Abrahamson, the Honorable Christine Durham, and the Honorable Margaret Marshall. How about a round of applause? It is truly an honor to have all of them here this evening. The Association established this lecture in Justice Ginsburg's name to celebrate her groundbreaking contributions to the advancement of women's rights and her achievement as a lawyer, a law professor, and judge. I want to take a moment to thank Joan Cray, who chairs our Ginsburg Lecture Committee. Joan conceived the idea for this lecture and has been the driving force behind this lecture and all 5 previous lectures. Many thanks also to Martha Harris for her efforts in making this lecture a success. I would also like to thank Justice Ginsburg as well for allowing us to create this distinguished lectureship in her name. Justice Ginsburg, we appreciate your continued close involvement with the lecture, and we are honored by your presence here tonight. Through our committees and our Office for Diversity, the City Bar has worked hard and continues to work hard to eliminate gender bias in our laws, our courts, and our profession. Through our efforts, we are building on the foundation of great pioneers such as Justice Ginsburg, without whose groundbreaking contributions to the advancement of women's rights, we would surely be worse off today. Justice Ruth Bader Ginsburg has long been a strong voice for justice, gender equity, and civil rights. From the beginning, she has worked to eliminate gender bias in our laws and in our courts. After finishing top among the women in her class at Cornell University, she went to Harvard Law School, where she was one of only 9 women in the class of 1959. After facing difficulty finding a job upon law school graduation, in 1963 she became only the 2nd woman to join the faculty at Rutgers University School of Law. Some of my most enjoyable moments at Rutgers Law School were spent listening to Justice Ginsburg, then Professor Ginsburg, explain conflicts of law. I'm sure she does not remember me, but I can assure you that I do remember her and the influence she had on my colleagues at school. At Columbia Law School, she became the director of Women's Rights Project of the ACLU. While with the Women's Rights Project, Justice Ginsburg participated in cases, many before the United States Supreme Court, which paved the way for new and better opportunities for women. It is now my distinct honor to invite Justice Ginsburg to the podium.
This time of year, as the court gears up for its final sitting rounds, my spirits need a little lifting, and there is no occasion that could serve that purpose better than this annual gathering. My thanks to the Association of the Bar of the City of New York for continuing these special evenings, and to 2 people who have been mainstays of the lecture, Barbara Opatowski, the Executive Director of the Association, and Lynn Schafran, who was first my student, then co-worker and friend. I am reminded, when I consider these annual lectures, of a program that was popular in my youth. It was called Can You Top This? And each year, Barbara and Lynn come up with a super program to engage our minds and renew our energies and our hopes for the future. I am feeling blue about being the lone woman on the U.S. Supreme Court. But Barbara and Lynn rightly remind us to look beyond the marble palace that is my workplace and to take account of the positions women now occupy in numbers and not as one-at-a-time curiosities on federal and state benches. Currently, 17 and soon to be 18 women are at the helm of state judiciaries as Chief Judge or Chief Justice. Tonight's 4 panelists are front-runners in that regard. I will not intrude too deeply on their time, so my introductions will be brief, as their CVs are long and impressive. In alphabetical order, Shirley Abrahamson, who is the longest tenured of any of us. She was first appointed to the Wisconsin Supreme Court in 1976 and became Chief Justice of the Wisconsin court system in 1996. Up for election every 10 years, Shirley won handily in 1979, 1989, 1999, and she assured me tonight that she will run in 2009. In her earlier life, she practiced law in Madison and was a tenured member of the University of Wisconsin Law Faculty. Shirley continues to teach all over the United States and around the globe. She has lectured on the art of judging and on sound judicial administration in diverse places on 7 continents. Though Madison, Wisconsin has been her home for more than 4 decades, she grew up, as I did, in this great city. She earned her bachelor's degree from NYU, and today, among her many extracurricular activities, she serves on the board of NYU Law School's Institute of Judicial Administration. Christine Durham was appointed to the Utah Supreme Court in 1982 after serving as a trial judge for 4 years. She became Chief Judge in 2002. Chris was a founding member of the National Association of Women Judges. She is a former president of that organization and has been awarded its highest honor. She serves on many blue ribbon boards, commissions, and committees, including one, Chris, that I volunteered for unsuccessfully many times in the 1980s, the U.S. Judicial Conference Advisory Committee on Rules of Civil Procedure. If you want to know the secret of successfully combining work and family life, consult Chris Durham and her husband, George. Parents of 4, Chris Durham and her husband had their first child just 2 weeks before she entered law school, and their second child during her 3rd year of law school. She has been a leader in diverse educational endeavors from grade school to graduate school and in programs to educate judges. Perhaps that interest stems from her own experience as a newcomer to the trial bench in 1978. Offered no training, she was simply handed a borrowed robe and a case file and told, "Go be a judge." I had the pleasure of serving with Chris and with Shirley Abrahamson on the ALI Council. Both Shirley and Chris continue to bring to council meetings and projects their bright minds, keen insights, common sense, and sound judgment. Judith S. Kaye, to the good fortune of our profession, gave up her college dreams of becoming a banner headline news reporter when the best job she could land was a society page reporter for the Hudson City, New Jersey newspaper. Her second chosen career had more upward mobility. Appointed to New York's highest court the Court of Appeals in 1983. She became the state's chief judge 10 years later. Judith took over a large, less than orderly system very much in need of reform. Through patient, persistent efforts, she has succeeded measurably in making New York's judiciary more user-friendly in the face of daunting odds. Most recently reported by the New York Times, she is launching a pilot collaborative family law center in this city designed to lower the cost, delay, and contentiousness of divorce proceedings. Before her appointment to the bench, Judith was one of the few women to achieve success as a commercial trial lawyer and in becoming a partner in one of the city's large law firms. Judith and Shirley Abrahamson have much in common in addition to their New York State origin. Both are past presidents of the National Conference of Chief Justices and past board chairs of the National Center for State Courts. They are also members of the American Academy of Arts and Sciences and the American Philosophical Society, recipients of numerous high awards and honorary degrees. Judith, I think, ranks ahead of all of us, Chris will tell me if this is true, in one notable capacity. She is the proud grandparent of 6 grandchildren. One of the lessons in life she shares with others, it is hard to be a parent. It is easier to be a grandparent. Margaret Marshall, Chief Justice of the Supreme Judicial Court of Massachusetts, presides over the oldest top court in the country. First convened in 1693, the SJC is in fact the oldest continually running tribunal in the Western Hemisphere. Chief Justice Marshall was not born as a Boston Brahmin. She came of age in South Africa and earned her first degree from Wits University in Johannesburg in 1966. Margaret's leadership talent was evident in her endeavors for and her eventual election as president of the National Union of South African Students. Because of her anti-apartheid activities, South Africa was not a place in which she could live comfortably and free. Fellow activists raised money to send her to our shores, and somewhere between her studies at Harvard University and Yale Law School, she decided to stay. She became a partner in a Boston firm in record time, and in 1991 served as president of the Boston Bar Association. That same year, she left law firm practice to become vice president and general counsel of Harvard University, appointed an associate justice of the Supreme Judicial Court in 1996. She was named Chief Justice 3 years later. My dear and sorely missed colleague Sandra Day O'Connor once said, "For both men and women, the first step in getting power is to become visible to others, and then to put on an impressive show. As women achieve power, the barriers will fall. As society sees what women can do, as women see what women can do, there will be more women out there doing things, and we will all be better off for it." The 4 chiefs with us tonight fit that description to a T. They have all achieved positions of extraordinary prominence and have put on a most impressive show. For their service to their courts, their states, and our nation, please join me in saying to them, brava and encore.
My name is Lynn Hecht Schafran, and I have the great pleasure of being the moderator for this evening's program. Those of you who have been in the Great Hall before, and those of you for whom this is a new experience, know that this is a very difficult hall in which to organize a program like this, because I'm going to be sitting there and I won't be able to see those two speakers. The program is very informal. There are no prepared remarks. I have prepared some questions which I'm going to ask our panelists. The reality is that we could probably spend the whole hour on the first question, but we're going to ask everybody to be brief so that we can go through a few and after about an hour move on to questions from you. Now, this entire program is being filmed by C-SPAN. So it's very important that when you want to ask questions, you go to the microphones, which are where? There were two microphones over there before. They have vanished. Hand mics, okay. I think it would still be helpful if you do want to ask questions, if perhaps you would line up, as you see what time it is now, I don't even know, as we move toward the end of an hour, if you would line up so that someone who's handing you the microphone, you'd all be in one nice little space and nobody would have to run around and we wouldn't lose time that way. So welcome again, and let me move on to our first question. And I am going to sit down for the rest of this. The first question that I have is about some history about each of these women that I don't know and I'm interested in. I've known them all for a very long time, and I don't know the answer to this question. So it's about history, it's about trailblazing, and it's about how women are perceived today. The history of Justice O'Connor's 1981 appointment is that President Jimmy Carter had appointed a record number of women to the federal bench. When he came to the presidency, there had been all of 8 women on the federal bench in the history of the United States. When he left, there were 40. President Reagan, needing to respond in some way to this, made a campaign promise that if he was elected, he would, if the opportunity arose, appoint a woman to the Supreme Court. When the opportunity arose, organizations like the National Association of Women Judges pressed him to make good on that promise. Now, when Justice O'Connor was appointed, the country's focus was on her being the first woman on the Supreme Court. But Justice O'Connor has said repeatedly that her focus was that she not be the last. In later years, she said, "If I stumbled badly in doing the job, I think it would have made life more difficult for women, and that was a great concern of mine, and still is." As you've heard, 3 of our panelists were the first women on their state Supreme Courts. Justice Marshall was the second, and all 4 were the first women to be chiefs of their state courts. So my question for each of you is, what were the circumstances that made the governors in your respective states decide to make a little history of their own and appoint the first woman to the state Supreme Court and the first woman chief? When that happened, did you consider yourself a trailblazer? And if so, what did that mean then? And what does it mean now that there are other women on each of your courts? And finally, have we at last reached the point where the actions or the competence of one woman no longer represent the actions or competence of all, so that no woman who moves into a leadership position may have the same worry that Justice O'Connor did, that she will be the last? So I'm going to ask our panelists to respond in the order in which they went on their courts. Justice Ginsburg gave you that order, but it's Justice Abrahamson in 1976, Justice Durham in 1982, Judge Kaye in 1983, and Chief Justice Marshall in 1996. So,
can we rule the question improper in form? It is a...
I knew that I was going to get that, a compound question.
It is a multiple question.
It is indeed, but we are very pressed for time.
Well,
I'm fairly confident that one reason I got appointed was that in 1976, the women's movement was quite prominent, and that the emphasis on women achieving ranks in the legislative and executive and judicial branch was on people's mind, but I do not know why the governor appointed me, and I have never asked him. I merely said, thank you, Governor. But I used to joke that the governor and his aides sat around and said, what are the basic characteristics of being on the Supreme Court? And one of the aides said, you know, judges always complain they're overworked and underpaid. And the governor said, overworked and underpaid sounds like woman's work. And the governor instructed, so my story goes, the governor instructed the aides to make an alphabetical list of all the eligible women lawyers, which of course was a quite short list, and I was on top. And so he appointed me, and I think my story is correct because when you look at Massachusetts, the first woman to serve on that court was Ruth Abrams. And when you look at the California Supreme Court, the first woman was Rose Elizabeth Byrd. So I think that's quite appropriate. I don't think that I or any of the other women were appointed as tokens. I follow the Ruth Bader Ginsburg and Patricia Wald, that they are and we are beacons, and that lighting the way, and others will come, and they have come, and no woman, if there is such a woman who would not do well, I mean, I don't know if there is such a woman, but if she existed and she didn't do well, she would not ruin it for the rest of us. So we've reached that stage, I think, and hope. Did I answer all the parts?
Yes, you did. Thank you. Thank you.
Moving in alphabetical order, I actually think, I once heard Justice O'Connor speaking to a group of women lawyers in which someone asked her, how do you get to be on the United States Supreme Court? And she said, she quoted, I believe it was Potter Stewart, although I'm not certain of the attribution, of saying it's like lightning, you have to be in the right place at the right time. And that's true. I think all of our selection systems are different. I come from a state which has so-called merit selection, where the governor picks from a group of individuals who've been screened by a merit selection committee. But when the governor interviewed me for my position on the trial court, and I was the first woman in my state to go on the general jurisdiction trial bench in 1978, one of the things that mattered to him, I think, he was a moderate Democrat, believe it or not. We've had Democrats. We had 20 years of Democrats in Utah. Of course, that was 20 years ago. But one of the things that I know impressed him was the fact that he had a daughter-in-law who had gone to Wellesley College, and I'm a graduate of Wellesley College. And I have some classmates here in the gathering tonight. And so that made a difference to him. My activities made a difference to him, as well as my educational pursuits. And many of my activities were pretty feminist in nature. I had lobbied for ratification of the Equal Rights Amendment, first in North Carolina, where I went to law school after I graduated from Duke, and then in Utah when I moved there. You can tell how good an advocate I was by the fact that the amendment was not ratified in either North Carolina or Utah. But he appointed me to the trial bench, and I knew that I was very much on trial in many respects as the first woman. In fact, I was very young, but my gender was such an issue with the press that nobody mentioned my age, which in my review was a good thing. But I knew I was on trial. I worked very, very hard. I was the first one there in the morning, the last one out at night. I really felt that I was holding a standard for anyone who would come along after me. And 4 years later, when he decided to give me a vacancy on the state Supreme Court, when he called me, it's interesting you use this phrase, because when he called me, he said, "Are you ready to make history with me again?" So our governor in that era had a very real sense of the fact that this was a history-making moment in our state. I do think, and once again, although I was still young, even to be on the state Supreme Court, it was my gender that received most of the attention. And I do think that I was perceived very much as someone who was out in front, and I had the strong sense, accurate or not, that my success or failure would have a bearing on the chances of other people coming behind me. It took a long time for me to have an opportunity to serve as Chief Justice of my court, and I had a colleague once who wanted the job, at the same time I wanted the job, who said to me, "Utah is not ready for a woman chief yet." He's retired from the court now, and I'm chief. So some of this process is just outliving them all. Like Shirley, I really believe in my state, and I notice it nationally in my activities with the Conference of Chief Justices and other organizations. I really agree that we have reached a stage where it's no longer make or break. That women are accepted in positions of leadership in the state courts quite readily in most states, although there are still some states which have not yet had a woman as their Chief Justice. But I don't think it's going to be a big deal for them to have that experience. So to that extent, I no longer feel quite the same focus on my gender. And I must say that for the last 3 years, and for the first time in my nearly 28-year judicial career, I have a female colleague on my court. And that has been an enormous pleasure to me. It's great fun.
Thank you.
Well, I'm so pleased that between the year 1976, when Shirley went on the court, and 1982, when Christine went on the court, the alphabet devolved down to K, from A to K. But I think I feel a kinship in many respects, and probably my arrival on the court is very similar to theirs. A climate had been created in this state that made it not only, in the state of New York, that made it not only desirable, but really, really important that a woman, for the first time in the history of the Court of Appeals, which is our highest court, be appointed to the court. And at that time, Mario Cuomo was a candidate for the governor of the state of New York, and it was one of his campaign promises that if he were elected governor, that he would seek to appoint a woman to the court. It was my very good fortune that I was the woman. And isn't it great, as I'm listening to Shirley and Christine, that we do have such longevity on the court, that we not only have arrived there, but we've stayed there. In 1993, I had been a member of the Court of Appeals for 10 years when it became necessary to appoint a new chief judge. And again, I was fortunate to be appointed chief judge of the Court of Appeals, which carries with it as well the title chief judge of the state of New York. I was just renominated and reconfirmed again my 14-year term as chief having ended, and Governor Spitzer selected me again. And I had cause to go back since I'm preparing some remarks for my swearing in on Monday. And I noticed when I was sworn in, I was the quote of the day in the New York Times, which for the one and only time, and I think mostly I'm happy that I haven't been the quote of the day. And what I said on September 12, 1983 was, "I take my gender with me wherever I go." I do. I agree with both who have spoken before me that I don't think we're the end of the world if we have a decision that everybody disagrees with, but I take my gender with me wherever I go, and I think it's applauded. Today, we have 4 women on the Court of Appeals of the state of New York. Imagine that, from 0 women to 4 of 7 women. Governor Spitzer, when he was in our courtroom the other day, noted that this line about Albany, the legislative and executive branches of government being run by 3 men in a room wouldn't do a bit of good at the Court of Appeals. They'd be outvoted because there are four women. It's been for me nearly 24 years, and I must say pretty terrific years, made better, made terrific, made great by my 3 women colleagues, and by the wonderful friends who have become judges in other jurisdictions. I think that is extremely supportive for all of us. So yes, I do take my gender with me, bring my gender with me wherever I go. Margie?
Well, I'm the baby here in more ways than one, and first of all, I'm in the bottom half of the alphabet. I came to this country in 1968. I didn't know a single lawyer. I never thought I'd be a lawyer, and I never thought I would be a judge, and so the circumstances of both being a justice on the oldest court was not in my vision at the time. I came, as Justice Ginsburg mentioned, from South Africa with its terrible history of racial oppression and degradation, to find myself as a justice on the first court in the world that declared slavery inconsistent with the fundamental guarantees of the Declaration of Rights that begins the Massachusetts Constitution. So how did it happen? Judith talked about a climate. Almost 100 years before I became a justice, Lila Robinson filed a petition with the Supreme Judicial Court to ask to be admitted to the bar. And the then 7 justices, all men, all white, refused her admission and said that she simply couldn't be a mother and a lawyer at the same time. And on her shoulders, as Judith suggested, have been remarkable women who have refused to take the reality as it was presented to them, and even when they couldn't obtain the positions to which they were entitled when they graduated, they went on to become justices of the United States Supreme Court. And so the climate had definitely begun to be put in place by the time I came to Massachusetts. Like Judith, there were some expectations by that time. But in part, they were also formed by the women who sued major law firms because they were not admitted to partnership. They were the women who took the enormous risks of saying that they wanted to have a reduced workload so they could place their families first. And it is the case, as I think for all of us, that somebody broke the ceiling. In my case, it was Justice Abrams, Ruth Abrams, as Shirley Abrahamson has mentioned. Now, Judith is somewhat of an exception, but if you look at the women firsts, they tend to be rather short. And my view of that is that those women were bashing their heads against a concrete ceiling, and I just had an easy glass ceiling to break through. The last part of Lynn's question, I suppose, to me is the most interesting, which is to what extent are we still standouts? And like Christine Durham, I agree to some extent that we're not standouts. But I also know that while there are still relatively few women in positions of responsibility, authority, and yes, power, that each of us in some ways still continues to feel every day that we hope that we are making it easier for the men and women who follow us. I still find, for example, that when I speak at any group of people and say to them, families come first, that strikes a chord with people. It shouldn't strike a chord because for men and women, all of us know that families come first, but I think we haven't said it quite as loudly. And so I think in some ways we simply play out our roles as best as we possibly can. Now I have to tell you, within the Conference of Chief Justices, you must know how much easier it is for me to be able to do as I do frequently, which is to call Christine, to call Judith, to call Shirley and say, how do I deal with this and to know that I get just absolutely marvelous advice from all of them. So I'm delighted to be the baby on this panel. At least I have role models to follow.
Well, I thank you all, and my next question picks up on the theme that Chief Judge Kaye sounded about taking her gender with her. Looking back again to Justice O'Connor's appointment, her comment at the time about the impact of women on the court was, "I think the important thing about my appointment is not that I will decide cases as a woman, but that I am a woman who will get to decide cases." But she's also said, each of us brings to our job, whatever it is, our lifetime of experience and values. And for example, she's written about her own experience growing up in the Southwest on a ranch. She's written about how meaningful it was to her to hear Justice Marshall talk about his experiences as a lawyer fighting segregation in the Deep South. Justice O'Connor was openly thrilled when Justice Ginsburg joined her as the second woman Associate Justice, and openly critical when President Bush failed to appoint a woman to succeed her, leaving Justice Ginsburg, as she has said, as the only woman on the 9-member court. So here are 3 aspects of the diversity issue. First, the role model aspect, what my friend on the Nebraska Supreme Court, Lindsay Lerman, calls, "If you can see it, you can be it." The second is, how does life experience inform decision-making? And the third is, how representative of the population is the institution? My compound question again for our panelists is, do you think it's important to have a bench that reflects the population? And if so, why? And how have your own life experiences and as women and from your individual backgrounds informed your decision-making and your dialogue with your court colleagues? So let's begin to my far left with Chief Justice Durham.
I was afraid you were going to start with me because that's a really difficult question. The Institute for Court Management a number of years ago attempted to do a study of women on state Supreme Courts and to assess whether they decided cases differently. And they looked at constitutional criminal cases, and they looked at family law cases, and they looked at some statutory interpretation and common law decisions. And at that time, the sample was very small. This study took place, as I recall, in the very early 80s. And their conclusion was that the only area in which they could detect a difference in terms of the votes on cases and the outcomes of cases were in cases where women's rights in some direct way were implicated, and that the female judges seemed to have more engagement and empathy with those claims. They couldn't detect any other differences across the board. I've really wished that they would repeat that study now that there are so many more women on the bench, because I can think of very few decisions that I have made over the course of a long judicial history in which I can identify the ways in which my gender has had an impact on my vote. So many things go into the judicial process, and all of us, men and women on the bench, share a common educational process which has produced us as lawyers and ultimately as judges. And that's an enormous, I think, leveling influence on the way we do our work. At the same time, I can think of a few which involve, again, claims that to some degree are unique to the condition of women in American society. Claims involving domestic violence. One case in particular I recall from a number of years ago had to do with a tort claim for wrongful pregnancy, and I remember quite vividly the discussion in court. I being the only person in the conference at the time who'd actually produced children and taken primary responsibility for raising them, of the issue of whether a child born to a marriage could ever be, in any sense, a detriment to his or her parents, economically or otherwise. I had a slightly different perspective on that than my male colleagues, which I think my life experiences had an impact on. So I don't want to say that it never happens, but at the same time, I think there's so many influences on the judicial process that absent the research, and I know there's there are increasing opportunities for empirical research, which makes all of us judges a little nervous, but nonetheless it's very enlightening to see what the results are. I'm hesitant to say that I can identify areas in which my gender influences my vote, but I know that, like Judith Kaye, I carry my gender with me everywhere I go, and my perceptions of the world are, to a significant extent, influenced by the experiences I've had as a member of the female gender. So I'll leave it at that and let others offer views.
Justice Abrahamson?
Well, I think diversity on the bench is very, very important. I think it's very important for those who come to court and see a court made of judges and staff, a court that looks like the people in the country, so that it's not us against them, it's all of us in this together. So people looking at the bench should feel comfortable in court, thinking that everybody has an equal shot to be on the other side of the bench and staff and be heard fairly. And I think that diversity is very important for those who are on the bench and in the court staff, because we come with different life's experiences, and that they all go into decision making, just as Chris Durham said. And we have had 4 women on our bench, and we've had 3 women on the bench. We sit now with 3 women out of 7. On August 1, we will again have 4 women on the bench. If we vote together, it's because probably all the men have voted together too, and that you find it's very rare that it'll be a male-female split. In fact, I can think of only one case where that happened. And it was a trial court ordered a man not to have any more children because he had a number and he wasn't supporting them. And the issue before our court was that a legitimate order? And the 3 women said, no, can't stop them from having children. The 4 men said, yes, you can. So I thought that was an interesting split, but that's the only one as such. And we just bring our experiences. Now, I'm the daughter of immigrant parents, immigrant European parents who came to the United States with less than a high school education, who ran a neighborhood grocery store in New York City. My father had a heart attack when he was quite young, and it would have left my mother with 2 young girls to support. And it was sort of a wake-up call for the entire family that the girls better get an education so that they can support themselves and their families if they had to. And that was the emphasis in my family. I went to school in the city, public schools, and then New York University. People ask what brought me to Wisconsin, and I respond, I got married. And he wound up in Wisconsin at the University of Wisconsin, and so I, like most women in the 50s, followed my husband.
That's how I got to Utah, too.
That's right.
Coincidence.
And followed my husband to Wisconsin, and didn't turn out too badly for either of us. Been there ever since. And so I bring with me that I'm a wife of a non-lawyer, a mother of a lawyer, a mother-in-law of a lawyer, a grandparent, a practitioner in the law, and a teacher of law. And all of that comes with me on the bench. And what you want on the bench, a multiple court bench anyway, the way as we sit there, are different people, because they see the world somewhat differently, although we all have gone to law school and are well versed in the law. And they bring that to a collegial court where you can discuss the cases and reach a consensus or agree not to reach a consensus. So diversity, I think, is very important of all sorts in a multi-judge court.
Thank you. Chief Judge Kaye.
Absolutely. Affirm, affirm, affirm. Everything both Shirley and Christine have said. My mind was racing when Shirley mentioned the voting patterns, and I was thinking hard in my nearly 24 years on our court. I think the one time we split along gender lines when we were only 3 women was whether you could have fees on fees in stockholder derivative litigation.
It's New York, after all. I mean,
but I've been nursing that grievance for many years. If we had another woman on the court, the law would be otherwise in the state of New York. I think undoubtedly what Shirley and Christine have both said so eloquently is true, and I cannot think the number of times that I have emphasized in just wherever people will listen the importance of diversity in our courts, and I mean it with every fiber in my being. And Shirley is right. It matters to people coming into the courts that they see the spectrum of society, that our courts represent justice. After all, we bear the title the justice system. But I think it, and I agree, that it goes beyond a perception, and that indeed the life experiences that each of us bring, and each of us could make a list such as Shirley's. I'm happy to join in hers because it is such a good lesson on what we can each add to the strength of the decision-making process. The geographical balance is important. All the different skills and experiences we bring to the decision-making process are enormously important. And let me tell you, it's so hard sitting on the state's high court where you have only the responsibility to reach the right decision, so much harder than it is for a lawyer who is bound to represent a client zealously within the bounds of the law. But Lynn, I don't mean to preempt your next compound question, but I do want to add something because I hope you're going to get to it. I agree 100% with what Christine and Shirley have said about the decision-making process, the importance of diversity, and clearly our gender is one of the factors. I hope you will also ask about how diversity factors into our role as Chief Judge and Chief Justice, because there I think, my goodness, I think the national dialogue in the judicial branch has changed greatly over the past decade or so, when by coincidence we have had so many women Chief Justices, where we have a responsibility beyond decision making, where we are responsible for the operation and administration of the entire judicial branch, and where policy making is very much within our purview, unlike the decision making process where we are bound by the law.
I promise we're getting there.
Good.
I think I have very much the same experience, which it's hard to point to a particular case that says the gender made a difference. I think life experience makes an enormous difference, and I return to saying that gender was terribly important to me, but the experience that I had growing up in South Africa was equally important. And so you can imagine how extraordinarily painful it was when the Supreme Judicial Court had only one woman, and Governor Weld nominated me to be the second woman on the court, and the black community in Massachusetts pointed out that there had never been an African American on the court. And I can say that the person who was next appointed to the court was my wonderful colleague, Justice Roderick Ireland, a great graduate of Columbia Law School, and he is the first and only African American on that 7-person court. Does it make a difference? Of course it makes a difference. But it also makes a difference because my colleague, Judith Cowan, was a prosecutor for so many years, and she's tougher on prosecutors than I might be. It makes a difference that one of my colleagues has had enormous experience in zoning and land use matters. And so it's not flippant. You bring to all of this one's life experience. But like each of my colleagues, I remember what it was like to walk into every courtroom in the Commonwealth of Massachusetts, including the federal courtrooms, and see only pictures of a certain part of the population. And I'm looking around this absolutely wonderful room, and I am absolutely ecstatic to be looking straight at the portrait of Justice Ginsburg. Now, there's some very lovely guys out here as well, but it makes me feel a little more part of the system. One last thing, I may be the justice up here with the largest number of grandchildren. I have 7, 6 of whom are girls between the ages of 14 and 16. And for them, what they find most amusing about my life is that I get called Chief. They love to call me Chief. The fact that I'm a judge is neither here nor there, but they just love to call me Chief. And so I think we can lead right into Judith's next question, Lynn, which is what's the difference between being the chief and being a judge?
Well, once again, Chief Judge Kaye provides us with a wonderful segue, so here's my next question. As Chief Justice of a state Supreme Court, you don't only decide cases. You have enormous administrative responsibilities as the head of a court system with ever more complex demands and never enough money. And the country looks to you as a leader in the justice system nationally. Now, I know that each of you has initiated numerous innovative projects in both contexts. So this next question may feel a little bit like I'm asking you to choose among your children or even your grandchildren. But since time is short, I'm going to ask only for one example of each. One top issue that you focused on for your own state court system and why you chose it, and one issue that you have taken on nationally and why you chose that. And Chief Judge Kaye, since you wanted that question, let's start with you.
Oh, goodness. Well, first I have to say, Margie mentioned enjoying being called Chief. My favorite moniker that I got from a prisoner was Mother of Justice, Dear Mother of Justice. But now one initiative in the state of New York that was thrust on me when I first became Chief Judge back in 1993 was to do something, please do something about domestic violence. It was thrust on me by 2 murder-suicides in the state of New York, one in Kings County, one in Westchester County. And I was implored by the advocates and by a great many people to quickly bring myself up to snuff on issues of domestic violence, and boy, did I ever learn. And I feel pretty proud and extraordinarily grateful to all of the people who taught me, extremely proud of the response of the New York State court system to domestic violence and of our integrated domestic violence courts. And I said that was a lesson that I learned the hard way, not nearly as hard as the people who lost their lives, and there are so many of them. A national issue, Lynn, I guess I would have to point to jury reform, and maybe that began in my lawyer life when I thought that we could only do better in the state of New York, but it was honed in my chief judge life because I saw that there was so much we could do. That we have in the state of New York, we call 650,000 people a year into our courts to serve as jurors. And I saw an opportunity not only to make the justice system here work better, but also to garner some points in the column of public trust and confidence, and we all greatly need to do that. I'm very pleased that that became a raging issue for the chief judges and justices all across the United States. Arizona and New York clearly in the leadership, and Arizona now has a female chief justice too. But I would cite those as my one local and one national issue.
Okay. Chief Justice Durham?
This is a fascinating question, Lynn, because I think we all express the view that probably our gender hasn't had an enormous impact on the way we decide cases, but I think in terms of the issues we care about in reforming the justice system in this country, perhaps our gender does have more of an impact. And I think it would probably be inappropriate to go without noting that it was women coming to the bench at all, not necessarily as Chief Justices, but women coming to the bench and organizing themselves in the National Organization of Women Judges, which shortly hooked up with Lynn Schafran's project on judicial education for men and women in the courts, part of NOW, that began to identify issues like gender bias in the courts, the bias affecting not just women judges, but women as litigants, women as jurors, women as witnesses, women as attorneys, and has gone on to focus on a huge array of issues, including domestic violence, women in prisons. Lynn could help me out with the list here. And I'd also like to tell one other story. I'll, with apologies to Lance Liebman, who was not heading the ALI at the time this occurred, but I'd been a member of the ALI Council for a number of years. And it wasn't, the first time, we used to have these wonderful annual dinners with wonderful speakers talking about areas of law reform and interest. And it was the year the council invited Judith Kaye to talk about community courts and problem-solving courts. That was the first time in the councils of the ALI that which is a very venerable institution devoted to progressivism in American law, was the first time I'd ever heard the subject of families and children discussed in ALI circles. And the ALI has since gone on to do a project on family dissolution. So I guess partly what I'm saying is that women on the bench and women in positions of leadership on the bench have had an enormous impact on the agenda of reform for the courts in the United States. And if you look at the organization of Chief Justices, I think it's far more than a coincidence, as Judith Kaye suggested, that the Chief Justices have emerged as a major policy spokes entity for the American judiciary, and the timing of the emergence of so many women as Chief Justices. When I came in to CCJ, I think I was 24th at the time. We've dropped a few, but we'll build back up again. But it's during that period that issues of tremendous substance, things like jury reform, things like domestic violence, things like judicial education, have come to the forefront of court reform in this country. Now, just to answer the question now, and Judith mentioned too, so I'm going to sneak into, although I might be stepping on Shirley's toes because I'm guessing what one of hers may be, but one of the projects I'd like to mention actually is an outgrowth of an issue that was brought to the Chief Justice's Conference by a wonderful former Chief Justice in Minnesota, Kathleen Blatz, who's since retired from the bench, but she started building on the work of the Pew Foundation's Commission on Children in Foster Care in the United States. And she brought to the Chief Justices the notion that the Chief Justice, following the recommendations of the Pew Commission, the Chief Justice in every state should go home to her state and organize a high-level policy-making entity that could address the problems of children in foster care in that state. And I took that recommendation home and have put together what we call the Initiative on Utah Children in Foster Care, IOU, which is a wonderful acronym, which I owe to my wonderful administrative assistant, where we have representatives from the governor's office, the head of all the state agencies, the faith-based communities, the provider communities, the business communities, and have brought leaders from throughout the community around a single table to deal with the issues involving children whose lives have been disrupted by neglect and abuse and by the states having to take custody of them. That's having a profound effect. And at Last Word, Judith hosted a wonderful summit just last week here in New York, bringing together all of the teams working on that effort from around the country. And I believe you said we had 37 states.
We had 46.
46 states. Actually, what I heard was that there were only 37 state teams signed up, and Judith got on the phone, and then it was 48. But I really do attribute that to the kinds of concerns that leaders, and it's not that there aren't male Chief Justices equally concerned about those issues, but I don't think it's a mere coincidence that so many women were in positions of power when issues like that got on the table. The other issue I wanted to mention, actually, in my state was an outgrowth of our efforts at jury reform. we began to be concerned about the degree to which jurors who come to court usually end up with very positive impressions of the justice system.
The Massachusetts Constitution provides that there shall be an impartial interpretation of the laws and administration of justice. And when I first became Chief Justice, I had been a judge, as you know, for a very short period of time. I came straight onto the Supreme Court, and I've been there for fewer than 3 years. And I went around the Commonwealth listening to members of the bar and litigants and community people. And it quickly became apparent to me that substantive justice was fine in Massachusetts, but the administration of justice wasn't. At the same time, I started asking my law clerks to tell me the age of the child when the care and protection proceeding was first commenced and what the age of the child was now that the case was before the Supreme Judicial Court. And they had to put the age up at the top of their bench memo for me. I asked them to tell me for how long victims in terrible homicide cases had been waiting until the prosecutor could say, yes, it is over, there will be no new trial. And so the thing that I worked on most to begin with, which is not glamorous and it's not sexy, but it is making sure that transcripts are prepared on time, making sure that in criminal and civil cases you have time standards and then you have goals to improve the time standards every year. This is not sexy work, this is hard institutional work, and it means dealing with very complex organizations. And that work is ongoing. I think that we are, the only state that has adopted the major metrics of the National Center of State Courts for all of our courts, civil and criminal, to have improvements every year in terms of expedition and timeliness, which I think makes a huge impact on people who seek justice in our courts. The second very important one, and I know that all of my colleagues join with me in this, is that in many of our courts, and in particular in our family courts and housing courts, and those are the areas that most impact families, over 80% of the litigants are not represented by counsel. Now, we in this country have a constitutional right to appear in court without a lawyer. That was a hard fought-for right. And you just have to read Bleak House to understand why we fought so hard for that right. But we have to make it possible for people who are not represented by counsel to receive justice. And that means assisting judges and probation officers and clerks. Sometimes people are the most angry in family court, and they don't have lawyers to help explain to them what has happened. And all of us, I think, have undertaken major initiatives to help everybody in the court system, and in particular those litigants who come without counsel, to make this not an inside baseball game, but a system of justice that works for everybody with or without lawyers. And so if I were to point to two things, Lynn, I would say that those are two. I happen to know that each of the chiefs here have done precisely the same thing in their state courts as each of us has done jury reform and so on.
Well, I agree with everything that's been said. We're doing these in Wisconsin, and one of the advantages of the Conference of Chief Justices is we talk about all of this and borrow those programs that are steal, that's right, borrow. But it's all not copyright, and all on the websites, and borrow and improve on each other, and then it goes back to the home state. So I've ticked off here everything that's been said, and therefore I'll add one more on a statewide level, and that is that in a Midwest state like Wisconsin, which is not generally thought of as a state of immigrants, except in the 19th century, we have a large number of people who whose second language is sometimes English, and it not very well developed. And it is not justice if you come to court and cannot understand what is happening. And so we have developed, with the state and federal funding, a system of certifying interpreters so that we have impartial, neutral interpreters who can speak for, in translation, witnesses and litigants. And we think this is very important. In any year in Wisconsin, there might be over 100 languages in the court system. So, and I feel very strongly about this because over 50 years ago, my uncle came to visit. He was from South America, but was originally European and left Europe just steps ahead of Nazi Germans forcing him to flee. And as a result of being in Eastern Europe, he spoke Polish and Russian and German, and spent some time in Italy, so he spoke Italian, and then went to South America, so he spoke Spanish. And while he was coming up to New York City to visit us, he stopped in Miami, rented a car, and got a ticket. And I think the statute of limitations has passed, and he was brought into court and didn't understand anything, and so they went through all these languages that he spoke, and no one in court spoke any of them. And so he was faced with a dilemma, which is there was one language he did not yet reveal, and that was he spoke Yiddish. But he was very concerned about the specter of anti-Semitism, and so he had to make a choice of not understanding anything or worrying about anti-Semitism, and he decided it was better to try it, and he said he spoke Yiddish. Well, the judge spoke Yiddish, the court clerk spoke Yiddish, the reporter spoke Yiddish. So it was Old Home Week in Miami courthouse, and he was given a sufficient warning and spoke about what he has to do in the United States, and then went on his merry way. And as he would tell the story, his last line was always, "Only in America." Only in America. And I have remembered that well, and in America, everyone who comes to court should be able to understand what is happening in court. So we have concentrated on interpreters, along with everything else that everyone has said. On the national level, I've been active in the conference on incorporating tribal courts in the national conference. We have several Indian tribes in Wisconsin, and Indian tribes, as well as in New York and in Utah, have their own court system on the reservations. And they sometimes have concurrent jurisdiction with state trial courts. And so what you don't want are conflicting judgments and conflicting decisions. And so we have developed with our Indian tribes protocols to have conversations among the courts so that we avoid conflict. And we've developed that at the national level with the Conference of Chief Justices, and I'm very proud of that movement, and so are the Indian tribes in Wisconsin.
Okay. Well, I see that it is 8:15, and I have a lot more questions, but I'm going to ask one last question because I think that people in the audience probably have a lot of questions, and then if you don't, I'll get mine in, right? Wait just a second, I have to find this one. Okay. As more and more women have become leaders in every American sector, in educational institutions, in the business world, in nonprofits, in politics, and obviously in the law, there's been a lot of discussion and research about whether women have a different leadership style than men, and whether it's getting any easier for women to be at the top than it has in the past. So my last question for this part of the evening, again, a compound question, I do apologize, is what has been the greatest reward of being a woman leader? What has been the greatest challenge of being a woman leader? And if you had one thing to tell a new woman leader, whether Chase Rogers as the incoming Chief Justice of Connecticut or Drew Gilpin Faust as the new president of Harvard, what would that be? So I've kind of lost track of the bidding, but let me start at that end with Chief Justice Marshall.
Wow. I think the greatest reward in some ways has been to see so many women move into positions of leadership and power. My greatest concern at the moment is not so much in the judicial branch. All three branches have an obligation to uphold our constitutions. And I look at Massachusetts that has never had a woman elected as governor and has the first woman elected as Attorney General. I was trying to think, Judith, I don't think New York has ever had a woman governor. Utah, I think, has not had a woman governor.
Yes, we have.
Oh, you have?
We have.
Take it back.
I got to swear her in. It was great fun.
And Shirley, I don't know if you've had a woman governor. And I think part of that says to me that, and I mean this quite seriously, I hadn't been Chief Justice for more than 2 weeks, Judith, I think, when I was down in your office. And so it simply makes an enormous difference. I didn't only go to women Chief Justices, but it was just enormously helpful to have Judith right at hand. It's also wonderful, Christine Durham and I, Christine, I hope you don't mind my saying this, but we always go shopping together when we're at the Conference of Chief Justices. I mean, it's just, you know, I don't think I've been shopping with any of them. You know, Ron George, no, we're not going to go shopping with the Chief Justice of California. The challenge, I think, is a very simple one. We're not quite accustomed to hearing women speak power. And so it's not that our competence is challenged so much anymore. And again, I think of Justice O'Connor and Justice Ginsburg and Justice Abrams and women of that generation who really had to demonstrate their competence. But I think people react differently sometimes when they are listening to women who are speaking from a position of power. So the one piece of advice that I would give to the new president or the new Chief Justice or the new governor or the new anything is don't take it personally. It's really not personal. And just, you know, keep to your own basic values, surround yourself with some very smart, wise advisors, and listen. Listen really hard. I will display, I think, what I hope is my only first bias. I think women may have a slight advantage of being good listeners. I think it's partly because we've had to listen for so long that was somehow passed on down to us. I found that enormously helpful, and you can listen to everybody and have so much to learn. But the thing that I really want to say to all of the young women and young men and others is that if you let people define your careers, your goals, your aspirations, your dreams, your desires, or your loves for you, you will never find the real satisfaction. And as soon as you take the criticisms personally, I think you'll find your world constricting.
Chief Judge Kaye.
Well, I think I will accept everything that Margie has advanced as my personal answer to your question as well. I think she has said it so well, and I imagine each of us would do the same as we have done with all of your questions. I'll do what Shirley did and try to just add something a little bit different, and maybe it goes in the reward/challenge column, that surely a great reward for a person of my years in the profession, and they've been very good years in the profession. A great reward has been to see so many women advance into positions of authority and to do what they do so very well. But the slash part and the challenge, where I just have not seen significant reform, is in accommodating family. And this goes, I must say, both for women and for non-women. I don't think what I'm saying really is a woman's issue anymore. Maybe a woman's issue to reach the high office, to be the dean, to be the president, whatever. But this is something that very fundamentally affects the lives of men and women, and I think it's something we have to all attend to. I'm looking out at Susan Coleman in the audience because 20 years ago I did a study of women in big firms, and I was so privileged to enjoy the best myself before I went on the bench of large law firm practice. I called the piece I ultimately wrote The Progress of Women in Firms, but I was really being quite sarcastic. And I have to tell you that 20 years later, I don't see a sufficient change. I really do not see a sufficient change. So I think the challenge very much remains for all of us to find ways to achieve a fundamental change that accommodates personal challenges. And I hope all of us can work together on that. On advice, I guess I would tell others it's okay to be ambitious. I think it's important to be ambitious. That lightning strikes only if you're there in a place where it can hit you. The miracle can occur only if you put yourself in a place and have an expectation, in fact, that the miracle will occur. And be persistent. I think be persistent. Not be put off or shy or unduly self-critical, but believe that you can be successful and you will be successful. If you don't believe it, hey, nobody else will either.
Thank you. And Chief Justice Abrahamson.
Well, I agree with Margie and Judith, and so I'll add a different kind of reward. And one of my rewards is when fathers and mothers bring their young sons and daughters into court and introduce them, the children, to me and especially the other women on the bench, so that their message to the children is regardless of gender or race or ethnic background, you can do what you want to do in our great state, and you too can be, if you want, a lawyer and a judge. And I think that's a wonderful message to be able to give to young people, and so I find that extremely rewarding. It is a challenge, which all of us have had, of both having a career and being successful in family. And you have to make trade-offs, and you have to have a supportive family, and it's always a challenge to do that. As to my advice to new Chief Justices and the President of Harvard, relax, have a good time. It's okay to have fun. And I think that one of the things that all these chiefs do is they bring in all the staff and colleagues they have and listen and talk with them, get diverse opinions and views about the issue at hand after they get all the facts that you can. And then you have to use your best judgment and do what you think is right. And then you take full responsibility for all the errors. and you thank and give credit to all the people who surrounded you and helped you make the decision. And I think that those are marks of successful and good leadership.
And last but not least, Chief Justice
And
Durham.
I agree with everything that's been said. Let me just say, I think perhaps the most significant reward that I have experienced as Chief Justice has been the thing that Shirley just touched on, and that's the ability to associate with all of the incredible members of our judicial branch of government, and not just the other judges who do contribute and give of their off-bench time in so many important efforts, but the staff, the people who have embraced judicial administration as a career and a discipline, the counter clerks who are the interface between our courts and the public. That's been just so rewarding to me to see their dedication and their service. Perhaps the greatest challenge I've experienced is finding the time and energy to do it all. Shirley Abrahamson has been a mentor to me for many years, and especially after I became chief. And she's been telling me to relax and have fun for years. And I'm having fun, but the relaxing part is coming slowly, which takes me to the advice. My friend Ruth McGregor took over as Chief Justice in Arizona a couple of years ago, and I saw her recently at a meeting, and she said, you know, you gave me the best advice when I was coming in as chief. And I said, what was that? What did I say? And she said, you quoted, and I think at least the person I heard say it was Woody Allen, and I don't know what a great source he is, but and he was probably quoting somebody else, but he said, 85% of success in life consists of just showing up. And my point to her was that the judiciary has got to be maybe next to the Catholic Church, I'm not sure, but the most hierarchical institution left on the face of the earth. And when you become chief, you automatically have power. It's not personal power, although you can develop and infuse the job with personal power as well. But you have a mantle falls because of the responsibilities you hold. And that means that if you show up at an event, if you endorse a project, if you criticize an effort, your comments and your expressions have enormous influence and power. And apparently, Ruth was happy to have gotten that message before she started, and I must have given her the message because I didn't realize it for a while until I'd been on the job. So while I endorse all of the more general messages, I think in the judiciary, women are still learning how to exercise the kind of power that comes with high public office, and I hope we continue to have the opportunities to do it.
So I thank all of our panelists, and now we have an opportunity for questions.